Imagine waking up tomorrow to find that the immigration status you worked years to achieve could be at risk. Your green card, that precious document that represents your right to live and work in the United States, might not protect you the way you thought it did. What I'm about to share with you could fundamentally change how you understand your rights as a lawful permanent resident in America. Hello everyone, and welcome back to the channel. If this is your first time here, I'm your host, and on this channel we break down complex immigration news into clear, actionable information that actually matters to your life. Today we're covering something absolutely critical that every green card holder in the United States needs to understand right now. Congress has passed new immigration legislation that directly impacts lawful permanent residents, and the changes are more significant than most people realize. Whether you've had your green card for 20 years or just received it last month, what I'm about to explain could affect your future in this country. So make sure you're subscribed and have notifications turned on, because we'll be following this story closely as more details emerge. Let's dive right into what this new law means for you. The legislation that just passed through Congress represents one of the most substantial revisions to immigration enforcement policy we've seen in over a decade. Now, before panic sets in, let me be clear about something important. This law does not automatically revoke anyone's green card status. However, it does expand the circumstances under which lawful permanent residents can face removal proceedings, and it significantly increases the enforcement mechanisms available to immigration authorities. Understanding these changes is not about fear, it's about being informed and prepared. Let me walk you through the key provisions of this new law. The first major change involves travel requirements and continuous residence. Under previous regulations, green card holders understood that extended absences from the United States could potentially jeopardize their status, particularly when it came to naturalization eligibility. The new law tightens these requirements considerably. Lawful permanent residents who spend more than 6 months outside the United States in any 12-month period may now trigger automatic review of their permanent resident status. This is different from the previous system where such absences were primarily considered in the context of naturalization applications or at the discretion of immigration officers during re-entry. What does this mean in practical terms? If you're a green card holder who travels frequently for work, maintains property abroad, or cares for elderly relatives in your home country, you need to be extremely careful about documenting your ties to the United States. The burden of proof has shifted. Immigration authorities can now initiate removal proceedings if they determine that you have abandoned your permanent residence, and the criteria for what constitutes abandonment have become more stringent. Keeping detailed records of your U.S. employment, property ownership, tax returns, family connections, and the reasons for any extended travel is now more important than ever. The second major component of this legislation addresses criminal convictions and deportability. This has always been a sensitive area of immigration law, but the new provisions expand the categories of crimes that can lead to removal proceedings for green card holders. Previously, certain misdemeanors and lower-level offenses generally did not trigger deportation procedures unless they fell into specific categories outlined in the Immigration and Nationality Act. The new law broadens these categories significantly. Offenses related to what Congress has termed threats to public safety and national security now carry much more severe immigration consequences, even for lawful permanent residents who have lived in the United States for decades. Here's what makes this particularly challenging. The law includes retroactive provisions for certain types of convictions. This means that if you were convicted of an offense years ago, even if you successfully completed probation, paid all fines, and have lived as a law-abiding resident ever since, you could potentially face review of your immigration status under these new guidelines. The law does include some protections and waiver possibilities, but these require demonstrating extraordinary circumstances and significant hardship to U.S. citizen family members. If you have any criminal history whatsoever, even minor offenses, consulting with an immigration attorney now rather than waiting for problems to arise is absolutely essential. The third critical aspect of this legislation involves public benefits and the expansion of what's considered when determining whether someone might become a public charge. Now, current green card holders are generally not subject to public charge determinations in the same way that people applying for green cards are. However, This new law creates new pathways for reviewing permanent resident status based on public benefits usage. If immigration authorities determine that a green card holder has become primarily dependent on government assistance programs, this can now be considered as a factor in status review proceedings. The law specifically targets what it calls extensive or prolonged reliance on means-tested public benefits. The exact definitions are still being worked out in regulatory guidance, but the programs that appear to be under scrutiny include supplemental nutrition assistance, certain housing assistance programs, and some forms of Medicaid. There are exceptions for refugees, asylees, victims of trafficking, and other vulnerable populations, but the general framework suggests that green card holders need to be much more cautious about accepting public benefits, even those they are legally eligible to receive. This creates a troubling dilemma for families facing genuine hardship, and it's an area where we're likely to see legal challenges in the coming months. Another significant change involves employment verification and work authorization enforcement. The legislation mandates expanded use of electronic verification systems and increases penalties for both employers and employees involved in unauthorized employment situations. For green card holders, this primarily matters if you're starting new employment or if your employer conducts periodic re-verification of work eligibility. The system is now connected more directly to immigration enforcement databases, which means that any discrepancies or issues with your documentation can trigger alerts to immigration authorities much more quickly than before. The law also includes new provisions around fraudulent applications and misrepresentation. If immigration authorities discover that any information provided during your initial green card application was inaccurate, false, or misleading, they now have broader authority to revoke permanent resident status, even many years after the green card was granted. This applies even to relatively minor inconsistencies if they are deemed material to the original approval decision. The lesson here is that if you have any concerns about the accuracy or completeness of your original immigration applications, seeking legal advice now is crucial. One area generating considerable discussion among immigration attorneys involves the law's impact on naturalization eligibility and timing. Many green card holders eventually plan to naturalize and become U.S. citizens. Citizenship provides the ultimate protection against deportation and eliminates many of the concerns I've been discussing. The new law doesn't explicitly change naturalization requirements, but it does create additional complications that could affect eligibility. For instance, if you've triggered any of these new review mechanisms, even if removal proceedings don't ultimately move forward, there could be negative impacts on your naturalization application. Many attorneys are now advising eligible green card holders to seriously consider pursuing naturalization sooner rather than later. The enforcement mechanisms in this law deserve attention as well. Congress has allocated significant additional funding for immigration enforcement activities, including more immigration judges, additional detention facilities, and expanded investigation capabilities. This means that immigration authorities will have more resources to identify and pursue cases that fall under these new provisions. We're likely to see an increase in notices to appear, requests for evidence, and immigration court proceedings involving lawful permanent residents. So what should you actually do with this information? First, if you're a green card holder, now is the time to organize your immigration documents and supporting evidence. Create a file that includes your green card, passport, travel records for at least the past 5 years, evidence of continuous residence in the United States like lease agreements and utility bills, tax returns, employment records, and documentation of family ties here. If you ever need to respond to immigration inquiries, having this information readily available will be invaluable. Second, be extremely cautious about international travel, especially extended trips. If you must travel abroad for more than a few weeks, consider applying for a re-entry permit before you leave. Document the purpose of your travel and maintain clear evidence of your intent to return and your ties to the United States. Third, if you have any criminal history, any concerns about your original immigration application, or if you've received any type of public benefits for extended periods, consult with a qualified immigration attorney now. Don't wait until you receive notice of a problem. Early intervention can make an enormous difference in immigration cases. Fourth, if you're eligible for naturalization, meaning you've had your green card for the required period and meet the other criteria, seriously consider moving forward with your citizenship application. While naturalization has its own requirements and complexities, citizenship eliminates most of the vulnerabilities created by this new law. Finally, stay informed. Immigration law is constantly evolving, and regulatory agencies will be issuing additional guidance on implementing this legislation over the coming months. Following reliable sources of immigration news and updates will help you understand how these changes are actually being applied in practice. Thank you so much for watching today. I know this information might feel overwhelming or concerning, but remember that knowledge is power. Understanding these changes puts you in a much stronger position than being caught off guard later. If you found this video helpful, please give it a thumbs up and share it with other green card holders who need to see this information. The YouTube algorithm will help us reach more people who need to understand these critical changes. Drop a comment below and let me know if you have questions about any of these provisions or if there are specific immigration topics you'd like me to cover in future videos. Don't forget to subscribe and hit that notification bell so you never miss an update, especially as we continue following the story and bringing you new developments. Remember, your dreams of building a life in America are valid, and staying informed is your best tool for protecting your future. I'll see you in the next video, and until then, take care and stay empowered.